One.
Hi everyone, we are Group 10 and we are presenting today on the topic of judicial notice. Our group members are Michael Combs, Damian Gunn, Ariana Martinez, Ethan White, and myself, Rhett Parrott. The material on judicial notice can be found in Chapter 59 in our casebook. So the policy behind judicial notice is similar to other rules of evidence that we have studied, such as the business record and public record exceptions to hearsay. Judicial notice exists 1, for efficiency's sake, 2, to reduce the burden on parties to a litigation, and 3, to preserve judicial economy. The rule acknowledges that there are some facts that are so well accepted that it seems unnecessary for a party to have to take time to prove them. Things such as the fact that Election Day in the United States is today, November 3rd, 2020. Courts can take judicial notice of these facts so that they are assumed in the course of a litigation without parties having to bring witnesses or evidence in order to prove them. The way that I like to think of it is that it is the substituting of formal evidence in a courtroom, such as witnesses or testimony, with judicial notice of an obvious or indisputable fact. With this in mind, let's look at the individual parts of the rule. Next slide, please. Rule 201A lays out the scope of the rule. 201A says that the rule governs judicial notice of an adjudicative fact only, not a legislative fact. To understand how judicial notice works, it is vital to understand how facts are broken down with Rule 201A. Judicial notice splits facts into two categories, adjudicated facts and legislative facts. An adjudicated fact is a fact that is unique to the parties in the litigation and helps prove the elements of a specific case. For example, in a case involving reckless endangerment where a car speeds through a busy or high traffic school zone, adjudicated facts would be how fast the car was going or whether the defendant was drunk at the time of the event. Another example that I had found was a 1989 case called United States v. Ceballos. In this case, 2 DEA agents were surveilling a high drug trafficking area in Queens County, New York. They observed the defendants parked next to a payphone, with one defendant exiting the vehicle and making a phone call on the payphone. The agents noticed that the defendant was not engaging in conversation and recognized that this was what was known at the time as a beeper call, which was a common tactic used by drug dealers to arrange deals. This and other factors such as erratic and evasive driving led them to follow the defendants and arrest them after they had found a large amount of cocaine and $847 in their possession. The defendants appealed, saying that the alleged beeper calls and their other actions were not sufficient for reasonable suspicion. The court concluded that reasonable suspicion was present, and when analyzing the beeper call, the court judicially noticed that beeper calls are generally used in the drug trade by drug dealers to contact other members of their organization. To the court, this was a generally known fact within the trial court's jurisdiction, as they had heard numerous drug cases involving dealers using beepers. A legislative fact is a fact that informs the court's decision on a legal principle. So in the case above regarding the speeding defendant, the court could judicially notice a legislative fact such as that, generally, speed limits in school zones in Florida are 15 miles per hour. This is an extrinsic fact that informs the court's decision on a legal principle. Understanding the difference between adjudicative and legislative facts is important because Rule 201 only applies to adjudicative facts. So if a court takes judicial notice on its own, or if a party requests notice of a fact that is adjudicative, the court must run a Rule 201 test and follow the procedures prescribed in the rule to establish judicial notice of that specific fact in the case. Additionally, this means that judges can always take notice of legislative facts to inform their decision-making, since Rule 201 explicitly excludes them from the procedures that must be followed if the fact is adjudicated. Next slide, please. Moving to Rule 201B, once the fact is determined to be adjudicated, there is a two-part test that needs to be satisfied to secure judicial notice. First, the fact must pass the initial threshold that the fact cannot be subject to reasonable dispute. Second, the fact must fall under either of the categories listed in 201B1 and B2. The first category is that it must be generally known within the trial court's territorial jurisdiction. So going back to our example earlier involving reckless endangerment, where the defendant sped through a busy school zone, the court could take judicial notice of where the school zone was located, including what street it was on, and the length of the school zone. The second category is where the fact can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned. This would be something that is not readily known to the court's territorial jurisdiction, like before, but can be reasonably ascertained. So if a case needed to determine, say, the general incubation period for coronavirus. The court could look to sources such as the CDC to determine that the general incubation period is 2 to 14 days. Next slide, please. Moving to Rule 201C, this part of the rule explains that the court has discretion in taking judicial notice on its own, or if a party requests and provides information on the fact, the court must take judicial notice. So judicial notice must and is required to be taken only when the party requesting it has provided adequate background information for the judge to review. The rule allows for the judge to acknowledge and notice the fact, but also deny judicial notice on a fact that a party requests. Next slide, please. I will now hand it over to Ariana Martinez to discuss the other half of Rule 201.
Thanks, Rhett. So the second half of the rules, subsections D through F, cover when the court may take judicial notice, the rights of a party to be heard regarding the taking of a judicial notice, and the relationship between the judge and jury when a judge takes judicial notice of a fact. So the first of this half, 201D on the slide here, states that the court may take judicial notice at any stage of the proceeding. This means that the taking of judicial notice is not limited to the pre-verdict phase of the trial, and not even limited to the trial court itself, but as you can see, can be taken at the appellate court level. This subsection is complemented by 201E. Next slide. Rule 201E states that on timely request, a party is entitled to be heard on the propriety of taking judicial notice and the nature of the fact to be noticed. If the court takes judicial notice before notifying a party, the party on request is still entitled to be heard. Now, this opportunity is limited since the judge does not have to conduct a formal hearing, but may just provide some opportunity to be heard. Additionally, the judge has discretion to take judicial notice without giving any prior notice to the parties. At that point, if a party disagrees with the decision made by the judge, it has the opportunity to argue before the judge in the hopes that they might persuade the judge to withdraw judicial notice of that fact in their favor. Next slide. So the rule concludes with 201F, which clarifies the relationship between the judge and the jury when the court takes judicial notice. This subsection states that in a civil case, the court must instruct the jury to accept the noticed fact as conclusive. This is because if a fact is beyond reasonable dispute, the jury can't reasonably find contrary to that fact. The rule also states that in a criminal case, the court must instruct the jury that it may or may not accept the noticed fact as conclusive. This has the effect of protecting the rights of the defendant and preserves the role of the jury as the final arbiter of all facts in criminal cases. Next slide. Now, Florida has its own version of Rule 201, which is covered under Florida statutes, sections 90.201 to 90.207. These sections include all of the portions of FRE 201, but adapted to Florida's conditions. This means that many of the adjudicative facts covered by the rule relate to Florida laws and regulations, rules of court, and common knowledge among Floridians. For example, section 90.201 states that a court shall take judicial notice of decisional, constitutional, and public statutory law and resolutions of the Florida legislature and the Congress of the United States, and rules of court of the U.S. Supreme Court and of the U.S. Courts of Appeal. Listed here are sections which cover what facts may or must be covered, how request for judicial notice works, and the generally known and accurate and ready determination equivalents from 201B in the federal rules. Next slide. Listed here is the second half of these sections, which reflects subsections 201C, D, E, and F of the federal rule. As with the federal rules of evidence, the court may take the initiative to take judicial notice on its own. It may instruct the jury to accept facts as judicially noticed, and it does not preclude courts from taking judicial notice of matters in subsequent proceedings. Unlike Federal Rule of Evidence 201, Florida Statute Section 90.205 describes a process for when the court denies a request to take judicial notice. This section states that, upon request of counsel, when a court denies a request to take judicial notice of any matter, the court shall inform the parties at the earliest practicable time and shall indicate for the record that it has denied the request. In all, the Florida statutes on this topic reflect many of the attributes of the federal rule. Next slide.
So now I'll go ahead and take over to explain judicial notice in practice. So facts that can be taken under judicial notice must satisfy either of the two prongs as described by Rhett in Rule 201B. These facts can range from well-known, proven instances, such as the sun rising in the east and setting in the west, to often made generalizations, like bingo being a senior citizen pastime. The first prong applies locality to the judge's decision. Facts known in a jurisdiction can be judicially noticed, even if they are not nationally known. For example, a judge could most likely take notice of the fact that Tim Tebow is a local hero in this district. The second prong applies to facts or notions that can be readily determined from accurate sources. This helps save time for parties introducing documents under the hearsay business records exceptions. It saves the court and the parties the trouble of calling witnesses and participating in lengthy hearsay battles. Now, judicial notice can change over time. Since generalizations can change over circumstances, culture, and time, judicial notice cannot often be applied to the same facts in every case. In Gardner v. Louisiana, a group of African Americans participated in a sit-in at a white-only restaurant. They did not make any speeches or cause any violence or do anything wrong other than sit at a white-only lunch counter. The police then removed the protesters and charged them with disturbing the peace. At trial, the judge took judicial notice of two facts. High racial tensions existed in Louisiana, and the group's conduct was alarming and disturbing to the public and notorious throughout the community. Obviously, these judicial facts are extremely controversial. It would most likely not be able to be taken under notice in today's society. Now, judicial notice can also occur in other judgments. Under judicial notice, judges can recognize as fact other judicial decisions or decisions coming from various government agencies. These decisions are extremely well documented and readily verifiable, which satisfies the second prong of 201B. And again, it just helps save the court time and energy during extremely lengthy trials. However, judges can only take judicial notice of the final judgment provided in the agency or judicial decision, not the facts underlying that decision. In State v. Kenny, the trial court took judicial notice of a disputed adjudicated facts in a case involving domestic abuse, child endangerment, and a custody battle with the state. Defendant Kenny and his girlfriend Ashley were involved in a custody battle with the state over their daughter Lily. Kenny abused alcohol, methamphetamines, and other drugs while domestically abusing his girlfriend Ashley. In a separate trial, Ashley entered a plea admitting she let Kenny supervise Lily despite knowing that Lily was at a significant risk to be domestically abused by Kenny. In Kenny's trial, the court took judicial notice of the facts alleged in Ashley's trial. Quote, "The court, upon its own motion, takes judicial notice that just before trial, Ashley admitted to the same when she entered a plea of admission that she engaged in domestic violence with Kenny and has failed to take the steps to address the domestic violence, placing the children at risk of harm. The court finds that by taking jurisdiction of the same factual basis applies to Kenny. Any domestic violence, whether the children are present or not, normally occurs more than one time. Although there may be one incident that suggests that the court finds that the case law is clear that the children do not have to wait for actual harm to occur for the state to intervene. Now, the Supreme Court of Nebraska correctly held that the trial court impermissibly took judicial notice of the disputed facts in Ashley's trial and applied them to Kenny's case. Only judicial judgments can be noticed. Now, in Rule 201F, the language gives the jury a choice on whether it will accept judicially noticed facts in a criminal trial. This addition in the rules seems to be in place when one considers the standard of beyond a reasonable doubt. A jury must consider every possible issue and fact in a case in order to properly convict or release a criminal defendant. While in theory, this provision would allow a jury to question everything, it is largely used to prove jurisdictional elements of crimes. For example, it would be rather cumbersome and possibly confusing to explain the differences between state and federal jurisdiction to a jury when there are more important issues at hand. Additionally, many crimes have to involve certain jurisdictional elements in order to be fully proven. I will next hand it over to Ethan.
There is one more concept to cover called stipulations. Stipulations are not quite the same thing as judicial notice. Let's talk about what exactly stipulations are and why they are different from judicial notice. Traditionally defined, a stipulation is a voluntary agreement between the opposing parties concerning the disposition of some matter before the court. In other words, the opposing attorneys have agreed not to dispute a particular fact for the purposes of the litigation at hand. They can be informal concessions made during the course of a trial or more complex written agreements drafted during the pretrial process. Another difference between stipulations and judicial notice is that stipulations do not have to be indisputable facts. While judicially noticed facts are indisputable, stipulated facts are undisputed. Yes, I know, that doesn't sound like much of a distinction, so it might help to put it this way. A judge can place a fact in the realm of facts that cannot be disputed, while the lawyers can agree to simply just not dispute a certain fact at all. Next slide, please. So, you've probably noticed that, this time around, it's the lawyers, rather than the judge, deciding which facts shouldn't be disputed. Why would attorneys, who seem to agree on nothing, actually agree on something? Well, there are a few practical and strategic reasons for this. Practically speaking, attorneys want to save time, or at least don't want to waste it. Generally, arguing over details that both sides could easily acknowledge as true is pointless. Next slide, please. To illustrate the strategic reasons for stipulations, let's get into some hypothetical litigation scenarios. Say that Daniel is out one evening and he's had 14 too many vodka martinis. A pretty girl drives up in a Ferrari and challenges him to a race, and he promptly jumps into his Aston Martin. As he speeds down the street, Daniel does surprisingly well, at least until he crashes into another Aston Martin driven by Pierce. Plaintiff Pierce brings suit alleging severe damage to his car and his hair. He just had it styled, and the wreck caused it to get unacceptably tousled. Next slide, please. Defendant Daniel would be wise not to contest every single aspect of Plaintiff Pierce's claim. He should offer to stipulate to the fact that he owned the car that crashed into Pierce's. If he denies owning the car, he's going to look silly, especially if the car is licensed to him and there are pictures of him emerging from it just after the accident. Next slide, please. Now, let's make this a criminal matter. Prosecutor Payton wants to bring DUI charges against defendant Daniel. Daniel is stubborn and would rather take this matter to trial rather than accept a plea deal. But even so, he wants to stipulate to the injuries caused to Pierce's hair. Daniel knows the jury will not be kind to him if they hear in detail about how awful Pierce's hair looked after the accident. If the parties stipulate to the injury, Daniel can admit it and be done with it. The only problem is, Prosecutor Payton can refuse to stipulate for that very reason, because the state has the right to prove every element of the crime charged and is not obligated to rely on the defendant's stipulation. So, Payton wants to prove Pierce's hair injuries so that the jury hears every heart-wrenching detail of the tragedy. Next slide, please. A prosecutor's refusal to stipulate even has the backing of the Supreme Court. In his opinion for the case Old Chief versus United States, which we actually discussed earlier this semester, Justice Souter explained why prosecutors have a strong motivation not to stipulate. Quote, "But there is something even more to the prosecution's interest in resisting efforts to replace the evidence of its choice with stipulations. A prosecutor who fails to produce evidence related to a criminal case or some good reason for his failure has something to be concerned about." End quote. The noted criminal defense attorney James Joseph Duane decries this view of stipulations as unfair. Quote, "The admissibility of evidence is determined by its capacity to influence jurors' hearts as well as their minds, even in ways that are not strictly logical, and even if the evidence has not rational tendency to prove any historical fact that is disputed at trial." End quote. Next slide, please. Fortunately for the defendant, if the prosecutor's evidence is highly prejudicial and outright unnecessary due to the fact that the defendant has admitted to what is in question, then the judge might require the prosecution to accept the stipulation. Similar logic informs stipulations regarding the defendant's intent, where Rule 403 mandates that the prior bad act evidence be excluded in favor of a defendant's clear stipulation to possessing the requisite intent. Next slide, please. But at the end of the day, whether or not the fact that the injury to Pierce's hair is agreed upon by the attorneys, the jury is not bound to consider that fact undisputed, because this is a criminal case and the rules are the same here as they are for judicial notice. So it's up to you, ladies and gentlemen of the jury, to decide if Daniel should pay the price for messing up Pierce's hair. Now we're going to do some hypos in class.